It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. Give me space. When I walk into the place, keep your eyes on straight. Eyes on straight, keep your eyes on straight. Eyes on straight, keep your eyes on straight. Okay, I be the Black Avenger, more greater than Alexander. Number one contender, more money in my agenda. Be the king of my castle, enjoying all of the splendor. Yo, shout this on me on Tinder, she might be gone to November. That's my old life, Chick-fil-A waffle fries on my bull bites. Creeping through the street, shit, I'm finna have me a whole wife. Niggas still searching, I'm ghosting ladies like poltergeist. And got they smell up off me like Old Spice, you know I'm right. Hey, that's a damn shame. I don't be rocking name brands, I'm a brand name. That's how the cash came. I put some money on myself and made a bet. Had my bills stuck in jeopardy like a Malik Trebek. I put my life in these 16s. Always they chapel like the 16. Everything clean, shining on pristine. But try to play me my sick team. Got them for greens, digging for that gold like 3 kings, my nigga. Give me room, give me space. When I walk into the place, keep your eyes on straight. Eyes on straight, keep your eyes on straight. Eyes on straight, keep your eyes on straight. Wait, give me room, give me space. When I walk into the place, keep your eyes on straight. Eyes on straight, keep your eyes on straight. Eyes on straight, keep your eyes on straight. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everyone's doing well out there. It's been a while since we've had a conversation about Daystar Peterson, aka Tory Lanez, on this channel. And he's got some interesting stuff going on. I don't know if anybody actually paid attention to the fact that he sued the prison where he was stabbed last year. But last month, there was a lawsuit, $100 million lawsuit, by the way, that he issued out on the prison, the warden, and the guards who were present in the prison at the time of the stabbing. Basically trying to allege that there was of course, negligence, lack of care, lack of proper security, emotional distress, all of these different types of things that he's trying to get out of the state of California for the incident. But again, this happened last month. He put it in and filed it. Since the stabbing took place, he's actually been removed from the facility that he was in. He's been taken to another facility. And now he's filed an emergency motion where he's claiming that he feels like his life is in further danger. He feels like the guards that are operating over a program, a mandatory program that he has to do. It's a self-improvement course that he has to attend. And he feels like he's now being threatened by the correctional officers that are overseeing him at the program and in his habitation area, to where he now feels like they're targeting him. He says that he feels he's in danger of possibly being moved to a more dangerous part of the prison because I guess they're filing little offenses on him. In his words, he feels like he's being noted for behavioral issues, I guess you could say. Which, after so many offenses, I'm guessing he would be moved to this other part of the prison that is more dangerous. And he says that they're doing this on purpose and that they've made remarks inside the jail that give him the inkling that they are targeting him and want to see him taken out. Okay? So what I'm going to go ahead and do is I'm going to pull up the paperwork of these allegations and just give my natural feedback to what's going on. You know what I'm saying? So this paperwork was filed by Crystal Morgan and Rhonda Dixon. They are his current
legal team. Okay. And this was filed in the United States District Court, Central District of California. Okay. Daystar Peterson, an individual plaintiff versus Doe Correction Officers 1 through 50. This is from his $100 million lawsuit. Danny Samuel, who is the warden of the facility, California Department of Corrections and Rehabilitation, a public entity. All right. So this is an ex parte application for temporary emergency relief pursuant to Federal Rule of Civil Procedure 65 and Local Rule 65, proposed temporary restraining order, declaration of counsel, and proposed order to show cause. So they say comes now, plaintiff Daystar Peterson, and buying through his attorneys, Crystal Morgan and Rhonda Dixon, respectfully filing this ex parte application for temporary emergency relief and request for order due to ongoing retaliation, intimidation, and harassment stemming from the filing of his complaint within this honorable court. So he feels like he's being retaliated against after suing the previous prison. This application is based on the accompanying declaration of Crystal Morgan, counsel for Plaintiff Peterson, which contains a declaration regarding notice, the pleadings, and papers on filing this action, and any oral argument the Honorable Court may permit. Declarations are attached. Plaintiff Peterson further humbly requests this Honorable Court allow this application and supporting exhibits to be filed under seal, as averred in his separate application, or in the alternative to redact as necessary to protect sensitive custodial and safety information. So he wants this to be sealed. Plaintiff seeks only the narrowest relief necessary to prevent unnecessary disclosure and retaliation. Background. Plaintiff Peterson is housed at the California Men's Colony in San Luis Obispo, located at Highway 1, etc. He is in a tier where all of the men being housed attend a DPR, Division of Rehabilitative Programs, self-help mandatory class. The DPR class is supervised by a female correction officer and a correction officer who are also the guards on this unit. It is oversaw by a supervising officer. Due to ongoing threats, intimidation, and harassment reported to Plaintiff Peterson's counsels of record, they bring forth this motion humbly to request intervention as they fear for plaintiff's life. So he knows how to cooperate with the courts when he feels like he's in danger, quote unquote. But he refused to cooperate with the courts when the woman he shot was being harassed. Allegedly through him. It has been stated by a correction officer that the purpose of the retaliatory conduct is to move Plaintiff Peterson into a more dangerous housing yard, as fully described in the attached declaration. A correction officer has also referenced Peterson's near-fatal attack last year in a threatening manner. Therefore, there is an immediate and irreparable harm to the plaintiff rising to this emergent application with a reasonable fear for plaintiff's safety. Legal standard. A temporary restraining order is appropriate where the moving party shows immediate and irreparable injury, loss, or damage will result before the parties can be heard. The request must be supported by specific facts and an affidavit or verified complaint. The Supreme Court's framework requires you to show likelihood of success on the merits, likelihood of irreparable harm in the absence of relief, and 3, that the balance of equities tips in your favor, and 4, that an injunction is in the public interest. As applied in California, the Ninth Circuit, in Alliance for the World Rockies v. Cottrell, held that its serious questions approach remains viable after winter, but only when it is applied as part of the full 4-element test. The serious questions must regard the merits while using a hardship balance that tips in the movement's favor to support the issuance of an injunction. Again, this is provided if the movement also demonstrates a likelihood of irreparable harm and that the injunction serves the public interest. Plaintiff Peterson is asking for relief due to an issue that does meet the serious question approach taken in California, as this issue stems from his current litigation. The hardship balance is in Plaintiff Peterson's favor as we are discussing his safety versus a correction officer who can follow policies and regulations in the normal course of business. It is in the public's interest to provide relief in such a situation as there is a great interest regarding any inmate safety. And here we are discussing a celebrity musician who has millions of supporters, allegedly. The likelihood of success on the merits of the underlying action also supports plaintiff. In alliance with the 5 elements of retaliation found in Roe v. Robinson, the plaintiff was 1. Engaging in protected conduct, i.e. redress of the government for grievances. 2. Subjected to adverse action, retaliated and threatened. And 3. There is a causal connection from the protected conduct and adverse action, which 4. Caused a chilling effect. And 5. There was a true lack of a legitimate correctional goal. As averred in his complaint, plaintiff was attacked while under the custody and care of the California Department of Corrections and Rehabilitation, which I'm sure there's thousands upon thousands of other inmates that have been attacked the same way who never received a $100 million settlement. But we'll continue. Said incident nearly caused plaintiff to lose his life and has left him with physical and emotional scars. As this incident was captured on surveillance video, the likelihood of success under the winter test has been met. Plaintiff is receiving capricious violation write-ups for non-infraction activities which do not have a legitimate reason for correction, as these alleged violations only began after the filing of the underlying complaint. So they're claiming everything was all good until he filed his lawsuit. Such actions have a chilling effect on all people who are incarcerated, as it demonstrates to plaintiff and other individuals what will occur if they exercise their First Amendment right to redress the government for grievances. Plaintiff Peterson seeks precisely the type of emergency relief that Rule 65 was designed to provide. This is not a case involving speculative or hypothetical future harm. The retaliation, threats, and interference with plaintiff's access to the courts are ongoing, immediate, and escalating, and they place plaintiff at risk of further injury before the court can hear the matter on full notice. So basically, they're trying to make it seem like the guards in his new facility are trying to cause harm that would either make him shut up or perhaps put him in a situation where he might die before he's able to actually make it to court to plead his argument for his $100 million lawsuit against the prison. The previous prison, by the way, not the prison he's currently in, but the one he was housed in last year. The conduct at issue is an ongoing threat to plaintiff's safety. Such a harm cannot be undone by a later judgment or through money damages. Once retaliation occurs, the harm would further be irreparable, as plaintiff Peterson is now forced to expose sensitive records, which is likely to create further harms by said correction officer. Importantly, plaintiff has shown that the requested relief is narrowly tailored. He is not requesting any orders upon the underlying complaint, as he is merely attempting to protect himself from retaliation that stemmed from the filing of said action. This is the proper use of injunctive relief. Now, what I find very interesting here is that he's willing to proceed to court. They say he's willing to expose sensitive records that could possibly put him in further danger, but he was not willing to take the stand and advocate for himself in the case that actually resulted in him being imprisoned. Make that make sense. The balance of equities is also tipped for plaintiff Peterson, as the correction officer will suffer no legitimate prejudice from an order requiring them to avoid retaliation, preserve records, and refrain from contact beyond normal security functions. Plaintiff, on the other hand, is facing immediate danger if the conduct continues. Public policy favors safety for all persons, whether incarcerated or otherwise. It also supports access to the courts, which retaliation chills. It has been determined in California courts that filing grievances, complaints, or reports of staff misconduct constitutes protected First Amendment activity. Prison officials may not retaliate against an incarcerated person for invoking these rights. The Ninth Circuit has held that threats, intimidation, warnings, or punitive actions constitute adverse action. Moreover, it has been established that causation may be shown through direct evidence, circumstantial evidence, or temporal proximity. When retaliatory conduct follows closely after protected activity, courts infer retaliatory motive. Plaintiff Peterson's declaration establishes that the actions in question occurred immediately after plaintiff engaged in protected conduct, strongly suggesting a retaliatory motive. Importantly, the Ninth Circuit does not require a plaintiff to show they were actually chilled from pursuing action within a court, as the question is whether the action would chill or silence a person of ordinary firmness. Threats and retaliatory punishment are far more than sufficient. Finally, even if a penological justification is asserted, it would still be unlawful if the evidence shows that such actions were motivated by a retaliatory intent. A temporary restraining order is therefore necessary to prevent irreparable injury and preserve the status quo until the court can conduct a preliminary injunction hearing. Here we have his prayer for relief. Plaintiff Peterson respectfully requests the court enter a temporary restraining order directing that A, the identified correctional officer has no direct contact with Peterson except as strictly necessary for ordinary functions, but at no time are the correctional officer and Peterson to be alone. Okay? Who is the identified correctional officer? The name has not been disclosed. The correctional officer and institution personnel be ordered not to retaliate against plaintiff for exercising his legal rights as permissible under the laws, local rules, and the First Amendment's guarantee to redress our government for grievances. C, the institution preserves all related video, incident reports, logs, electronic mail, memoranda, grievances, and other records, stating that perhaps there may be some public records from the prison to substantiate his claims. Now, here we have a written declaration from Crystal Morgan, who is Tory Lanez' lawyer, or at least one of his attorneys, because the other one is Rhonda Dixon, who's also had a controversial last couple of years. So Crystal Morgan says, I, Crystal Morgan, being duly sworn, declare and state as follows. I'm an attorney, licensed, we don't need that. I make this declaration based upon my personal knowledge, and if called as a witness, I could and would testify competently to the matters set forth herein. This affidavit is submitted under penalty of perjury pursuant to the laws of the state of California. Plaintiff Peterson respectfully requests that the court permit the filing of this declaration and any sensitive exhibits under seal or in the alternative in redacted form. As you can see, names have been blanked to the extent necessary to protect custodial safety and confidential information. So Miss Crystal Morgan, his attorney, is naming the actual officer in question, although his filing originally did not. For safety reasons, they say. Currently, Plaintiff Peterson has a pending action before this honorable court. He's being housed at the California Men's Colony. Is whatever. Officer Blank also oversees plaintiff's mandatory programming on Monday, Wednesday, and Friday. Since Plaintiff Peterson has filed a civil rights action within the statute of limitations to recover damages related to his near-death encounter at the California Correctional Institution, Correctional Officer Blank has engaged in ongoing harassment, intimidation, and retaliatory conduct. In May of 2025 at CCI, plaintiff was stabbed approximately 16 times with additional superficial cuts. Plaintiff was life-flighted to a local hospital as both of his lungs collapsed. While plaintiff was recovering, 2 of his notebooks were taken from him that contained notes between plaintiff and myself, along with unreleased music and personal thoughts. Plaintiff Peterson has reported to me and Ms. Rhonda Dixon that Correction Officer Blank began by making remarks as plaintiff would attend class. So just keep in mind, these are two separate facilities. He was previously in California Correctional Institution, where he was stabbed last year. And he's now in the California men's colony. And now that he's been moved to California men's colony, they claim that the correction officers on duty are now retaliating against him for filing a lawsuit against the previous facility. Okay? So here, Plaintiff Peterson has reported to me and Ms. Rhonda Dixon that correction officer blank began by making remarks as plaintiff would attend class. This included stating that officer blank. So now we can't even get a full view of the allegations because it's redacted. So we don't even know the nature of all of the actions. Now, officer blank, plaintiff Peterson. When petitioner received blank, plaintiff blanked. This is a more dangerous setting than what petitioner is currently in. The infraction started on or about April 27, 2026, which was a Monday. Plaintiff Peterson attended class blank. On or about April 29, 2026, plaintiff had his blank. The following Tuesday, May 5th, 2026, was the regular weekly inspection on Plaintiff Peterson's housing unit. For more than a year prior to this time, plaintiff was assigned as blank. Therefore, plaintiff was responsible for blank. The inspection was being conducted by correctional officer blank, who is blank on this tier. Officer blank. On May 8th, 2026, plaintiff Peterson attended the Monday, Wednesday, Friday, Saturday, and Sunday, Monday, class with his blank. Shortly thereafter, plaintiff Peterson received blank. As a crew was filming plaintiff for a documentary, this nigga doing a documentary in prison? So when the filings don't work, the camera will. As a crew was filming plaintiff for a documentary, another incarcerated individual blanked. When this individual was disciplined, blank. This caused the blank. Not only has his cell been trashed, but moreover, plaintiff has now lost blank. On or about April 29, 2026, I spoke with the litigation coordinator, commanding watch officer on duty, and left a message for the assistant warden. I also submitted this case to the Office of Ombudsman and have emailed them to update as the above incidences occurred. Plaintiff Peterson filed the necessary 602 forms to question the above infractions along with an excessive force complaint. These processes are still ongoing as he prepared for such complaints. He has found witnesses that heard officer blank. Emergency relief is necessary because the harm is continuous and cannot wait for a regularly noticed hearing. Plaintiff Peterson, myself, and co-counsel had hoped that the retaliation would cease. Notice should be excused because advance notice to the correctional officer or institution may itself trigger retaliation, intimidation, or further harm to plaintiff. The relief requested by Plaintiff Peterson is narrow, to prevent future retaliation and harm, and to preserve his rights while ensuring he is not being placed into a more dangerous housing unit for capricious reasons. Please help protect Plaintiff Daystar Peterson. We are not questioning this issue. Plaintiff has been in the work program and completing classes so that his current parole eligible date is August 2029. Interesting. So, check this out. So, they claimed that he was going to be out last year. They said he was going to walk. There were some people out there that said he would be out this year. He's returning home soon. Now, in his official attorney's filing to the courts about this retaliation, his whatever these issues are that he's having with the correctional officers in the facility that are redacted, I can't say whether or not they're happening. I'm not surprised that corrections officers may be harassing him in some form or fashion, especially after filing a lawsuit to the state. But now they're saying he's participating in a work program and other classes that would allow his parole eligible date to be August of 2029. Plaintiff has served his sentence for his base term charge and is now completing enhancement time. She says, I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. All I can say is this whole thing could have been avoided by not shooting a woman in the foot after a frivolous argument. But that sounds a little bit too much like right. You know? So there's that. Let me know what y'all think of all of this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I will catch y'all on the next one. And again, he's got an active lawsuit against CCI for $100 million for negligence. We'll just have to see how it goes up until this point. Looks like there were some incorrect filings and things of that nature. Maybe they've been completed. We'll see. Again, we don't get to see what the actual infractions are from the officer because it's all redacted, allegedly for his safety. So we'll just have to see. All right. I'll catch y'all in a minute, though. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'm never politicking, the drama be piling on. Father and great son acknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I'll turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy calls, consulting for the stakes I built. I had